Okay, so hello, my name is Ellen. I work for meemoo. We are a government organization supporting the cultural heritage sector in Flanders. And one of the areas we're supporting is the legal domain. The last years we get increasingly more questions in this area, not only because institutions generally give more attention to these issues, but also because the legal framework is becoming more and more complex and rapidly changing. And so in this talk, I will try to bridge a bit this gap between the legal text and scholarships on the one hand, and the daily professional practice in heritage institutions on the other hand. My focus, obviously, is a different one from Anastasia's. I'm looking at this really from the perspective of the archival institutions, cultural archival institutions in Flanders, and I'm focusing on social media archiving projects. So let's see if this works. Oh, I'll leave the questions for that. Why? So why do we care? Well, actually, of course, risks of copyright infringements is the last thing we want. And social media archive actually presents some specific challenges in this regard. So for one, the more recent materials are, this was just pointed out, the higher the risks are involved. And social media is, of course, amongst the most recent materials in our collections. So the platforms lifted off around 2000s. We also heard this morning. So that's less than 25 years ago. And copyright protection in Europe lasts 70 years and after the death of the creator. So there's no chance that any social media archives will fall into the public domain very soon. In fact, it actually occurs that we have social media in our archives that are simultaneously still available online, which is an interesting blurring of the traditional distinctions we make between statics and dynamic archives we see these days in the digital environment. So secondly, and this is particularly the case for social media archives, the number and variety of rights holders is extremely high. Social media archives are typically mixed media, so they will contain various types of works, text, illustration, photos, and so there can be many and different types of right holders involved. The individuals that created the stuff, for instance, a photographer, but it can also be an organization to whom the rights were transferred, for instance, with a public body and an employee who created content on their behalf. So a particular challenge with social media is also the user-generated content, and this is the specificity of the Web 2.0 applications. Everybody can become a creator. We co-create, we work together, the personal input, and this, of course, further complicates the copyright situation of social media archives. So, as in copyright law, as a general rule, you need to gain prior permission of the rights holder to use a protected work. But of course, due to the scale and the complexity of social media, this is just infeasible for cultural heritage institutions. However, this infeasibility of gaining prior permission is not a new problem. Given the long term of copyright protection, also much of the analog materials we have in our collection are still protected. And not only by authors' rights for creators, but there also can be neighboring rights for performers, portrait rights of depicted persons, etc. So this is a complex problem. In order to keep a fair balance between the rights of individual creators and then some competing fundamental public rights, such as the right of information, access to culture, copyright law systems foresee a number of exceptions that allow certain uses of protected material without the burden of gaining prior permissions. And cultural heritage institutions fulfill public tasks, so they are natural beneficiaries of these exceptions. Copyright is national competence, remains national competence. However, the exceptions have been harmonized on the European level. And the first milestone in this development was the so-called InfoSoc Directive from 2001, which had a list of 20 exceptions. And this two of them are specifically directed towards the cultural heritage institutions. One is the exception for preservation of cultural heritage that allows you to reproduce, to make a copy of a protected work. So this is an exception to the right of reproduction. The second one, we call it the intramuros exception. It allows you to give access on your premises of protected works. This is an exception to the right of communication. So, but it is important to note that this was a closed list. So member states can only choose exceptions from this list. So this was done to create harmonization across the EU. On the other hand, all the exceptions were facultative. So member states could choose whether or not to transpose them. And this again created fragmentation. So the first mandatory exception for CHIs is Orphan Works Directive in 2012. This allowed institutions to give access to works where the rights owner was difficult to locate, so you couldn't ask for permission. But because of on the upside, so it was mandatory across the EU, but the downside is in this context it's an item level based approach, and there's a big burden of procedures. So in practice, this was not really much uptaken by the heritage institutions. So finally, there is a DSM. We already heard about this. The latest EU copyright directive was adopted in 2019. It also updated legal exceptions for the CHIs. And one notable update is that now these exceptions have become mandatory, all of them. Then there are 3 exceptions specifically directed towards the CHI. First, there is the preservation exception, which already know. And it is notable to say that this is the only exception from the list of 20 that has now become mandatory through the DSM. So this indicates the importance attached to this preservation exception by the EU lawmaker. Next, there is an exception for TDM. That allows, and this one actually is complemented. There is one for the CHIs for scientific purposes, but it's all complemented by a larger one. I will not discuss it here because this is the one that is most debated on the commercial use of TDM. But interestingly, both the exception for preservation and the TDM exception are not only mandatory, but also binding. So this means that there is no contractual override possible. And this comes with the point that was written just before. And we also see this in case law. These exceptions are more and more viewed in a positive way as a right of the heritage institutions to preserve, to collect, to data. So we're going to this positive right thing. And finally, there's an exception for out-of-commerce works, which allows to give access to works that were never or no longer in commerce. And this one is complemented with a licensing system. So in the next slide, I'll take a closer look at how these 3 exceptions can be applied to social media archiving by archival institutions. And as a case in point, I would look at the Belgian transposition, because even the DSM allows for some room for national interpretation. I will only present like this a brief summary of some key findings of research we've done over the last 3 years. So please feel free to contact me if you have further questions, because I can talk hours about this. Okay, so let's start with the preservation exception. What does the DSM says? It says the beneficiaries are cultural heritage institutions. This is great because this is a very broad application field we have here. It is an exception to the right of reproduction, so the heritage institution can make copies of protected works. Interestingly, they can make them in any format or medium, so this allows great technological flexibility. However, the purpose is more limitedly defined, as for the purpose of preservation and the extent necessary for the purpose of preservation. So this again limits it more. It primarily brings reconversion into scope from the analog to the digital. However, it also said a copy at any point in the life of the work, and we can read this as, okay, this can be applied to born digital materials too. So also in scope are third parties acting on behalf of the heritage institutions. For instance, a commercial partner that does a digitization project for you, he works under the same exception. And this was, okay. The most difficult one actually is the fact that the work should be part of a permanent collection of cultural heritage institutions. So you need to acquire them through legal deposit law, donor agreements, etc. But there, what we see is that there are some exceptions. For instance, in Belgium, we already had a preservation exception a long time. And what we see is the fact that the works need to be part of the permanent collection. This is not a requirement in Belgium. Why? This requirement was not in the InfoSoc directive. And so the Belgian lawmaker decided not to take it up. So we are in a happy situation in Belgium because we don't need a legal deposit law or donor agreements to be able to take stuff in based on the preservation exception. And this is especially important for the archival institutions I work for that are private archives, and we don't have this robust framework of legal deposit, etc. So we are good on that side. Then there's a TDM exception. The great advantage of the TDM exception is actually that it does not have this limitation that the works need to be in your permanent collection. And so it's much broader. You need to have legal access to works, and legal access, even publicly available online, is a legal access. So the scope is much broader. The problem here is that it said it should be for the purpose of scientific research. And so here is the question, okay, should this be a predefined scientific project, or can we say structuring archiving? Well, for future scientific projects, can we bring this under this definition too? This remains unclear, so it's a new exception. Things need to be clarified in the future. Another thing is there's no contractual override. Interesting, it becomes a right. In this case, there is no opt-out possibility for this specific exception. What is, on the other hand, not clear is how far we can collaborate with commercial entities under this exception. Should we look at the wider TDM exception? And what is a very good thing about this exception is that most countries have transposed it very verbatim. So it's a very unified solution in law text over most countries. So that is something that really helps. And then lastly, there's out of commerce works. This is something we really don't know whether we can use this for our purpose here. The system is very new in its infancy. It is supposed to, we could think that websites that are offline, for instance, that are no longer commercially available, maybe in the future we will be able to use them, give online access to them under this exception. But the exception in many countries, the transposition in many countries is not yet completed. For instance, in Belgium, we are still not using it because we are waiting royal decrees. So this is something I hope, and maybe with input from the sector, we could advance on this because there might be options here. So as a conclusion, for the cultural archives in Flanders, we have a really good shot at archiving social media mainly through the preservation exception. We can do a lot through this. The download through the archival creator can be covered with this. Even API access is covered through this. It is more difficult for hashtag archiving, mainly because you have a lot of bycatch in hashtag archiving, where we cannot say, okay, this has a heritage purpose, and the heritage purpose is the requirement for the preservation exception. So, but there we can look at the TDM exception. So, okay, there are possibilities here. So we think we're quite good. Let's zoom out for you guys on a more general scale again. You should look at your national law, and look what the preservation exception says. In any case, it is now mandatory. This wasn't the case before. There's also the mandatory TDM exception. So there will probably be some new possibilities for you to archive social media or websites. In terms of access, it's more complicated. There's has been a problem. We've heard this in the talks before already. the existing options are all optional. Only the Orphan Works Directive and the Out of Commerce Works are mandatory, but these are, the Orphan Works is not usable because item-based and Out of Commerce needs to be seen. Question for the future. So go at these websites, look at your country, at your institution profile, and maybe, well, find out what the implications are for you. And I'd be happy to hear about that next year in this conference. Thank you.